Start. The state government, while prescribing the essential qualifications or desirable qualifications, are best suited to decide the requirements for selecting a candidate for nature of work required by the state government, and the courts are precluded from laying down the conditions of eligibility. If the language in the rules is clear, judicial review cannot be used to decide what is best suited for the employer. The proposition of law is culled out by the Honorable Apex Court, as well as this court clearly mandates that the court under Article 226 of the Constitution of India cannot trench into the province which is earmarked for the rule making authority and discharge the role and the function of the experts to prescribe a particular qualification for a post to be filled, namely the academics. The submission of learned counsel for the petitioner that there is inconsistency in the prescription of the qualification provided in the advertisement in question vis-a-vis the qualification prescribed by the Medical Council of India in the regulations of 1998 is thoroughly misconceived. From bare perusal of the advertisement in question, it is clear that it stipulates the condition that the qualification prescribed in the regulations of 1998 is to be followed and a candidate is to be selected on the basis of said qualification. The Honorable Apex Court in the case of Ashish Kumar versus State of UP and others 2018-3 SCC 55 has cautioned in para 27 as under. Any part of the advertisement which is contrary to the statutory rule has to give way to the statutory prescription. Thus, looking to the qualification prescribed in the statutory rules, appellant fulfills the qualification and after being selected for the post, denying appointment to him is arbitrary and illegal. It is well settled that when there is variance in the advertisement and in the statutory rules, it is statutory rules which take precedence. In the context, reference is made in the judgment of this court in the case of Malik Sultan and another versus UP Public Service Commission and others 2006-9 SCC 507. Paragraph 21 of the judgment lays down above proposition which is to the following effect. The present controversy has arisen as the advertisement issued by PSC stated that the candidates who were within the age on 1/7/2001 and 1/7/2002 shall be treated within age for the examination. Undoubtedly, the excluded candidates were of eligible age as per the advertisements, but the recruitment to the service can only be made in accordance with the rules, and the error, if any, in the advertisement cannot override the rules and create the right in favor of a candidate if otherwise of legible according to the rules. The relaxation of age can be granted only if permissible under the rules and not on the basis of advertisement. If the interpretation of the rules by PSC when it issued the advertisement was erroneous, no right can accrue on basis thereof. Therefore, the answer to the question would turn upon the interpretation of the rules. There is another aspect of the matter which is to be taken notice of and be addressed with regard to the undisputed fact that the advertisement in question as well as the selection for the post of lecturer in statistics is being challenged after a period of 4 years. The advertisement itself was issued way back in the year 2015. The writ petition has been filed in the last of the month of October 2021, whereas the date of the interview has been fixed on 9/11/2021. Neither there is any pleading with regard to the reasons for delay in approaching this court, nor any serious argument has been raised in this regard by the learned counsel for the petitioner. Thus, the writ petition is also hit by laches. The Honorable Apex Court in the case of P.S. Sadaswamy versus State of Tamil Nadu 1975 1 SCC 152 has considered the question of laches and held as under. If the appellant was aggrieved by it, he should have approached the court even in the year 1957 after the two representations made by him had failed to produce any result. One cannot sleep over the matter and come to the court questioning the relaxation in the year 1971. In effect, he wants to unscramble a scrambled egg. It is very difficult for government to consider whether any relaxation of the rules should have been made in favor of the appellant in the year 1957. The conditions that were prevalent in 1957 cannot be reproduced now. It is not that here is any period of limitation for the courts to exercise their powers under Article 226, nor is it that there can never be a case where the courts cannot interfere in a matter after the passage of a certain length of time, but it would be a sound and wise exercise of discretion for the courts to refuse to exercise their extraordinary powers under Article 226 in the case of persons who do not approach it expeditiously for relief and who stand by and allow things to happen and then approach the court to put forward state claims and try to unsettle the settled matters. The Honorable Apex Court in the case of in S.S. Balu versus State of Kerala 1998 2 SCC 479 observed thus. It is also well settled principle of law that delay defeats equity. It is now a trite law that where the writ petitioner approaches the High Court after a long delay, reliefs prayed for may be denied to them on the ground of delay and laches, irrespective of the fact that they are similarly situated to the other candidates who obtained the benefit of the judgment.